without court officials, that is the chief registrar, the registrar of this court, and the clerk who usually calls the file that has to be read. However, these files that having been called this morning, I am proceeding to read my consolidated reasons for the decisions I arrived at in the applications that were made in this petition. Before I read, I want to note that my file has been confiscated by the Chief Justice of Uganda. And nevertheless, I'm working from a duplicate copy. I'll not be able to read everything in my ruling, but I'll make an effort to do what I can. So, counsel who are remaining, please introduce yourselves.
May it please you, my lord. I am Samuel Gizzi, appearing jointly with Mr. Sekanjako Africa, the petitioner.
Please turn off your phone.
Africa Sekanjako. For the petitioner, Africa. The matters coming up. I wish to note and record.
Yes. I noted before I left that counsel for the respondents are left. Is there anyone for the respondents? Yes.
For the record, there is no counsel for the respondents in this matter, and neither is any representative. We are ready to proceed.
My lord, I think I also need to be on record. For purposes of application number 3 of 2021, where I'm the applicant appearing in person.
Mr. Mabidi, this morning your file was not called. So the right procedure is that I will need to finish with the applications that were called, and then I'll call your application to my room. Before I give my reasons, I wish to the unfortunate developments this afternoon, where the Chief Justice of Uganda has attempted to gag me by denying me the opportunity to read a ruling detailing my reasons for the decisions I arrived at in the petition that was withdrawn. As some of you who are here this morning know, the court convened with all the members of the quorum, and the Chief Justice directed that the rulings of the court would be read first, and then I would have an opportunity to read my ruling at the end. After the 3 rulings were given, the Chief Justice, who is the head and has been the head of the quorum, announced that the court was taking a recess and that would return in 30 minutes. To my surprise, when we convened after the break, I was informed by my colleagues that they could not join me to read my ruling, as I had done when they were reading the majority ruling. The reason they advanced is that I had not circulated my ruling for them to review. And my response was that we arrived at the decisions in all the rulings. We already arrived at our decisions. We already made the rulings. What is contained here are the reasons why we made the rulings that we made. While it is good practice for a member of the court to circulate their draft ruling colleagues, there is no law in Uganda that I'm aware of that requires me to do so. I would have loved to circulate my draft to my colleagues before, but as you heard from the rulings, the 45 days that the Constitution requires us to finalize this matter constrained my ability to do so. Nevertheless, the whole court was aware of my decisions in each of the 3 applications that were called today. So I'm very surprised that the Chief Justice of Uganda has chosen to use barbaric means and to use his powers in the manner that he has chosen to do so. The Chief Justice had further directed me that my ruling will be read at a later date, that he would choose to appoint, and after he and the other members of the quorum had probably vetted my ruling. I found that order unconstitutional, and I chose to disobey it. When I was appointed a judge of this court in 2009, I swore to uphold the Constitution of Uganda, and I also took the judicial oath. And I am acting based on those undertakings I made. I felt it my constitutional duty to disobey the orders, the unlawful orders of the Chief Justice, and to fulfill my duty as a member of this quorum to deliver my decision within the 45 days that are required under Article 104. With those remarks, I will now proceed to read in summary my consolidated reasoned ruling. The petitioner, or before I go to that, of course, on the directives of the Chief Justice, he ordered that all the microphones be switched off, that this tent should be closed, and I want to thank those who gave me directions to an open entrance. But even with this court being closed, this tent, which we turned into a court being closed, I was ready under the mango tree shade. So with those opening remarks, I want to now proceed with reading my ruling. The petitioner, Kyagulanyi Sentamu Robert, herein referred to as Kyagulanyi, filed this petition on 19 February 2021, challenging the outcome of the presidential elections that were held on 14 January 2021. He filed the petition against A, the first respondent, Yoweri Museveni Chibuharwa Kaguta, herein referred to as Museveni, who was declared the winner of the 2021 presidential elections. B, the second respondent, the Electoral Commission, herein referred to as the Electoral Commission. And C, the third respondent, the Attorney General, herein referred to as the Attorney General. I've talked about the representation of the parties by their lawyers, and I will not read it. Background. The background to this petition is that Kyagulanyi contested with 10 other candidates in the 2021 presidential elections. The elections were organized by the Electoral Commission and were held on 14th January 2021. On 16th February 2021, the Electoral Commission declared that Museveni had obtained 5,851,037 votes in the 2021 presidential elections, which amounted to 58.64% of the total valid votes that were cast in the said elections. The Electoral Commission then declared that Museveni, having obtained the highest number of votes and more than 50% of the valid votes cast, had won the 2021 presidential elections. The Electoral Commission also declared that Kyagulanyi had obtained 3,475,298 votes, which amounted to 34.83% of the total valid votes cast. The Electoral Commission further declared that the remaining 8 candidates obtained the following votes and percentages. I will not go over them. Kyagulanyi was aggrieved by the declaration by the Electoral Commission of Yoweri Museveni as having won the 2021 presidential elections. On 1st February 2021, he filed presidential election petition number 1 of 2021, in which he made the following allegations. 1, that the elections was invalid on grounds that it was not conducted in accordance with the principles laid down in the provisions of the Constitution of the Republic of Uganda, the Presidential Elections Act, the Electoral Commission Act, bear with me, other relevant laws, and that the non-compliance affected the results in a substantial manner. 2, that the election was invalid on grounds that offenses under the Presidential Elections Act were committed by the first respondent or with his knowledge and consent or approval, and that the entire electoral process was characterized by security agencies, in brackets UPDF and UPF, committing acts of murder, causing grievous harm, violence, abduction, and intimidation against the petitioner, his agents, and supporters across the country. Kyagulanyi sought the following declarations and orders from this court, which were laid out in his petition. 1, that the presidential election held on 14th January 2021 was not held in accordance with the provisions of the electoral laws and the principles governing elections, which non-compliance affected the results of the election in a substantial manner. 2, the respondent was not validly elected as the President of the Republic of Uganda. 3, the election of the first respondent as President of the Republic of Uganda be annulled and set aside. 4. A fresh election be conducted in accordance with the law. 5. The third respondent be directed again to cause amendment to the relevant electoral laws to comply with the observations, recommendations, and directives of this court in Presidential Election Petition number 1 of 2021, retired Dr. Kiza Besigye versus YK Museveni. Election Petition number 1 of 2006, Colonel retired Dr. Besigye Kiza versus Museveni Yoweri Kaguta and the Electoral Commission, and Presidential Election number 1 of 2016, John Patrick Amama Mbabazi versus Yoweri Kaguta Museveni, Electoral Commission and Attorney General, to enable internationally recognized principles of a free and fair election. It's really hot in here. I'm wondering whether I shouldn't go under the mango tree. The petition was supported by Kyagulanyi's affidavit dated 1st February 2021. In his affidavit in support of the petition, Kyagulanyi made over 180 affirmatives in support of his petition. All the 3 respondents denied the petitioner's allegations and affirmed that Museveni had been validly elected. They filed their answers to the petition. As the court was preparing to hear the petition, Kyagulanyi filed miscellaneous application number 1 of 2021 on 4th February 2021, seeking leave of this court to amend his petition. On 9th February 2021, this court unanimously declined to grant this application and ruled that it would give our reasons later in our main judgment. On 10th February 2021, the court held a pre-hearing where it released a roadmap for all parties to follow for the filing and serving of the affidavit evidence and for all other steps that needed to be taken to enable the court to hear the petition and to render its judgment within the 45 days dictated by the Constitution of Uganda. Kyagulanyi filed and served some of his affidavit evidence within the time that was allocated to him under the roadmap, but was unable to file the rest of his evidence by 5 p.m. on 14th February 2021. Kyagulanyi unsuccessfully engaged the registrar of the court administratively to have the rest of his evidence accepted. On 17th February 2021, Kyagulanyi filed miscellaneous application number 2 of 2021, where he sought from this court an order for extension of time by 1 day to file and serve his affidavits, which he was not able to file by 5 p.m. on 14th February 2021. On 19th February 2021, by a majority decision of 8, this court declined to grant this application. I dissented from the majority decision and allowed the application. The court ruled further ruled that the majority justices, as well as the dissenting justice, would give their reasons later in their respective rulings. On 24th February 2021, Kyagulanyi filed his third application, miscellaneous application number 4 of 2021, where he sought from this court leave to withdraw his petition. On 5th March 2021, this court unanimously granted him leave to withdraw his petition. The petition was accordingly withdrawn. The court similarly ruled that it would give our reasons for allowing the application and our decisions on the respective parties' prayers on costs of the application and the petition later. Prior to the petitioner applicant seeking leave to withdraw, Ewan Male Mabiri is hereinafter referred to as Mabiri, had also filed in this court miscellaneous application number 3 of 2021 on 19th February 2021. In this application, Mabilis sought for the Chief Justice to disqualify, recuse himself from participation in the hearing and determination of Presidential Election Petition number 1 of 2021. He also prayed to court to set aside 2 other rulings we had made earlier on Kyagulanyi's application to amend his petition, and also for extension of time to file additional evidence. I will discuss this application later. On 23rd February 2021, this court heard the Mabilis application ex parte. The Chief Justice declined to recuse himself for reasons that he would give later. The court did not rule on the remaining prayers. Although the court heard Mabilis' application ex parte, the whole application, including the submissions and prayers for the Chief Justice to recuse himself from the quorum of the main petition, were heard by the entire quorum hearing the petition. Secondly, all Mabilis' prayers had a direct bearing on the main petition, as allowing them would have led to a change in the quorum and a possible reopening of the hearing of the earlier applications that the court had already disposed of. That being so, I found it prudent to also render my decision on this application and the reasons for my decision in this ruling as well. So this consolidated ruling, therefore, will encompass my reasons for ruling in each of the 4 applications that were received in this petition. Reasons for declining to allow Kyagulanyi's application to amend his petition. On 9 February 2021, I joined my colleagues on the quorum hearing Presidential Election Petition number 1 to disallow Kyagulanyi's application, seeking leave to amend his petition to this court, where he had challenged the declaration of Museveni as the validly elected president in the elections that were held on 14th January 2021. I have since had the opportunity to read in draft the majority ruling of this court, giving the reasons why Kyagulanyi's application for amendment was not allowed. With all due respect to my colleagues, I do not agree with some of the reasons for the decision I arrived at with respect to the application for amendment of the petition. I'll begin with the law. I entirely agree with my colleagues that the law governing presidential election petitions in Uganda is found in Article 104 of the Constitution of Uganda, Section 59 of the Presidential Elections Act, and the Presidential Election (Election Petition Rules) made thereunder. Article 104 provides in the relevant part as follows. I will not read it in the interest of time. On the other hand, Section 59 of the Presidential Elections Act also provides for challenging the outcome of the presidential elections in similar terms as Article 104 of the Constitution. I have not found it necessary to reproduce it here, with the exception of subsection 11, which provides thus: the Chief Justice shall, in consultation with the Attorney General, make rules providing for the conduct of petitions under this Act. It's clear from the above provisions that both the Constitution and the Presidential Elections Act require the following. 1, that a petition challenging the outcome of a presidential election should be filed by any candidate who is aggrieved with the result declared within 15 days from the date the challenged results were announced. In this particular case, the results of the 2020 presidential election were declared by the Electoral Commission on 16th January 2021. 2, that once a petition has been filed, the court should expeditiously inquire into and determine it and give its reasons for its findings not later than 45 days from the date the petition was filed. 3, the Presidential Elections Petition Act gives power to the Chief Justice in consultation with the Attorney General to make rules providing for the conduct of petitions. Turning to this particular application, it's not disputed by all the parties that Kyagulanyi, the petitioner, filed his presidential election petition on 1st February 2021. In their pleadings, some of the respondents contended that Kyagulanyi's petition was bad in law because it was filed after the expiration expiry of 15 days from the date the election results were announced. It's indeed true that 1st February, when the petition was filed, was beyond the 15 days after the declaration of the presidential election results. However, it's also worth noting that the last day of the 15 days fell on a Sunday, which is not a working day. Secondly, the Chief Justice had not yet given directions for the record registry to be open on Saturday and Sunday, as is mandated under Rule 12(2)(c) of the Presidential Election Petition Rules. Nevertheless, in this case, the Chief Justice directed that the filing could be done on a Monday, 1st February 2021, and the petition was accordingly filed in court on that day. During the hearing of the application for amendment, Counsel for Kyagulanyi relied on the following provisions of the law stated in the notice of motion. I will not read them. Relying on the provisions, Counsel for Kyagulanyi contended that the provisions give power to the court to allow his application. He further relied on the following grounds briefly stated in the same notice of motion. One, that the applicant filed a presidential election petition on 1st February and served it on the respondent. 3, I'm skipping some of that filing of two, that filing of pleadings in the petition was still ongoing. 3, the amendment to the petition is necessary to enable this court to effectively investigate and completely determine all questions involved in the petition. 4, that the respondents shall not be prejudiced by the amendments to the petition. 5, that the proposed amendments to the petition did not raise a distinct cause of action in the place of the original. 6, that both the original petition and the proposed amended petition concern the same claim of right. 7, that it is in the interest of justice, equity, and fairness that the applicant be granted leave to amend his petition. Kyagulanyi's application was further supported by his own affidavit and an affidavit by his advocate, Tudayo, Geoffrey, and 2 supplementary affidavits sworn by him. In his affidavit of 8th February 2021, Kyagulanyi repeated the grounds in his notice of motion and further deponed as follows, and I've laid out what he said. In the said affidavits, Kyagulanyi deponed as to the reasons why he was seeking an amendment to his petition. The supporting affidavits of his counsel, Tudayo, also deponed to the same facts, and the fact that counsel could not access Kyagulanyi at his home for 10 days after the election results were declared by the Electoral Commission. He relied on the decision of this court in Amama Mbabazi versus Yoweri Kaguta Museveni and 2 others, where this court allowed the petitioner to amend his petition. He also relied on other decisions of this court, which have. The applicant further relied on Rule 22, 44, 42 and 44 of the Supreme Court rules. I've not found it necessary to reproduce these rules. This is because Rule 21 of the Supreme Court rules provides that they shall apply only to appeals from the Court of Appeal. All the 3 respondents, Museveni, Electoral Commission, and the Attorney General, strongly opposed this application. Relying entirely on non-Ugandan decisions, the respondents contended that the Constitution does not allow for amendment of an election petition outside the 15 days a petitioner is allowed to file. Secondly, they contended that although the applicant's movements had been restricted for 10 days, he still had access to his lawyers. Thirdly, they contended that Kyagulanyi's restrictions did not affect his ability to instruct his lawyers to prepare and file his petition. Fourthly, they opposed the application on grounds that the amended petition was introducing a new cause of action, that is the alleged lack of qualifications of Museveni, the winner of the elections, to stand for and to be elected as the President of Uganda. I have noted in the majority ruling of this court that they agree with the submissions of the respondents. With all due respect to counsel for the respondents and my colleagues on this forum, I do not subscribe to the alleged legal position that a presidential election petition cannot be amended after the expiration of 15 days following the declaration of those results. As I noted earlier, all the respondents conveniently ignored the binding precedent of this court over Mama Mbabazi, where we allowed the petition to be amended. The respondents did not canvass this issue, nor the issue why the court should not follow this earlier precedent. While it is true that Article 104 of the Constitution and Section 59 of the Presidential Election Petition do not expressly provide for amendment of the petition, none of the said provisions expressly bar this court from allowing amendments. In the past, this court has jealously guarded the jurisdiction conferred on it by the Constitution and refused to allow arguments by parties praying to the court to hold that its jurisdiction was ousted. And I give an example of a case where this court declined 201 for my employees of GS Security Services. This court declined to find that the jurisdiction of the High Court to handle employment matters had been ousted by the Industrial Court, which had not yet been set up for 5.5 years after the law was enacted. If this court declined to do so in a case where the law specifically provided otherwise, I would not subscribe to a view that this court's power to grant leave in proceedings before it could be ousted by a mere deduction that the power to amend is not expressly provided for. This court has always upheld its inherent jurisdiction to do justice to all parties as the circumstances of the case before it would warrant. In summary, I state that that is not one of the reasons I disallowed this application. Thirdly, the applicant also relied on Section 98 and 100 of the Civil Procedure Act, Rule 15 of the Presidential Election Petition Rules, and Order 6, Rules 19 and 20 of the Civil Procedure Rules. With the exception of Section 100, I found the remainder of these provisions applicable. Of particular interest is Order 6, Rule 9 of the Civil Procedure Rules, which specifically vests in this court power to allow a party to alter or amend pleadings, his or her pleadings. The rule provides as follows, and I've quoted it. The rule was applicable to a presidential election petition by virtue of Rule 15 of the Presidential Election Petition Rules, which provide that the Civil Procedure Act and rules made thereunder shall apply to presidential election petitions with such modifications as may be necessary. It's however important to note that while this court had the authority to allow the applicant petitioner to amend his petition, Rule 19 uses the word may, thereby giving the court discretion to grant or not to grant the application to amend. I will now turn to the issue of whether or not the application should not be allowed, because the proposed amendments would be introducing a new cause of action. The respondents contended that the proposed amendments of the petition, which was introducing the issue as to whether or not Museveni had the necessary qualifications provided for under the Constitution to be elected President of Uganda, was introducing a new cause of action after the expiry of the 15 days limitation period for filing a presidential petition. It is trite that the issue of persons who are eligible to stand for election as president is a matter of law. These qualifications are spelled out in Article 102 of the Constitution and repeated in Section 4 of the Presidential Elections Act. Section 102 provides as follows, and I have quoted the article, you can access it. On the other hand, Article 104 gives the right to an aggrieved candidate to petition the Supreme Court on grounds that the person who was declared as the winner of the elections was not validly elected. That being the case, the cause of action granted to an aggrieved candidate is to bring an action challenging the validity of the election of the successful candidate. I therefore do not agree with the respondents and the majority justices of this court that by the petitioner raising the issue of qualifications of Museveni, the winner of the 2021 election, or lack thereof, he was seeking to introduce a new cause of action. Contrary to the respondents' contentions and the majority of the court's view, I believe that the issue of qualifications of the president is not subject to the 15-day limitations rule. A petitioner or even any other person could have raised this issue before the presidential election was held or even after the elections are completed. In my view, a challenge to the qualifications or disqualifications of a presidential candidate cannot be extinguished on the basis of Article 104. Having been provided for in a separate article, it is my view that the petitioner did not need to amend his petition. I'm aware of the provisions of Section 59(6) of the Presidential Elections Act, which provide as follows. 6. The election of a candidate as president shall only be annulled on any of the following grounds if proved to the satisfaction of the court. And B, 1 is non-compliance with the provisions of this act if the court is satisfied that the election was not conducted in accordance with the principles laid down in those provisions and that the non-compliance affected the results of the election in a substantial manner. B, that the candidate was at the time of his or her election not qualified or was disqualified for election as president. C, that an offense under this act was committed in connection with the election by the candidate personally or with his or her knowledge and consent or approval. I note that Parliament was granted power under Article 104 of the Constitution to, quote, make such laws as may be necessary for the purpose of this article, including laws for grounds of annulment. Pursuant to this section, Parliament enacted Section 59(6)(b) quoted above. Although Parliament was acting within the powers granted to it under Article 104(9) of the Constitution, the inclusion of the ground of annulment in Section 59(6)(b) without referencing Article 102 of the Constitution from where it is derived led to the unfounded view held by the respondents that a successful presidential candidate's qualifications can only be challenged under Article 104 of the Constitution and Section 59(6) of the Presidential Elections Act. I hold the view that a constitutional challenge based on the lack of qualifications of an elected president, as provided for under Article 102, can be made, 1, before the election is held, 2, during the presidential election petition filed under Article 104(1), or at any time after the 15 days have lapsed, 15 days under Article 104 have lapsed without a petition being lodged in the Supreme Court, or 4, after the conclusion of a presidential election petition. It goes without saying that such a challenge is not brought within, such a challenge which is not brought within an Article 104(1) petition could be brought under Article 137 of the Constitution. I'm aware that my views above differ from the ruling of the court in this application, in which I concurred and where we unanimously ruled as follows with respect to this issue. Court finds that the issue of qualifications of the first respondent in the proposed amended petition is a new matter which comes outside the limitation period for filing a presidential election petition. Therefore, we disallow it. Having critically reviewed the constitutional provisions I have cited above, I have come to the conclusion that I arrived at a wrong decision to rule as above. While this is so, I'm aware that Article 132(4) of the Constitution gives this court a right to reverse itself in appropriate cases. It provides as follows. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. I'm further aware that although this right is vested in this court as a whole, this article does not exclude the possibility of a single justice of this court to depart from a position he or she has taken earlier. This is especially so in a case like this one, where there is a decision of the whole court and where therefore there is no option for reference from a decision of a single justice, as is in the case in the other cases where the court is exercising its appellate civil and criminal jurisdiction. Other than the above, I stand by the rest of the ruling of the court rendered on 4th February 2021. Having listened to the submissions of the applicant, I was convinced that he had made out his case that the restrictions on his movements by members of the police and army had adversely impacted on his ability to instruct his lawyers and to also prepare for his petition. I was further convinced that the applicant had been, quote, arrested in his house for 10 days by the police and the army, thereby losing 10 critical days out of the 15 days he was granted under the Constitution to lodge his petition to this court. The averments of Kyagulanyi and his counsel were validated by the order of the High Court issued in Kyagulanyi Sentamu Robert and Barbara Kyagulanyi Tungo versus Attorney General, Chief of Defense Forces and Inspector General of Police, High Court Miscellaneous Cause number 16 of 2021, where Elubu J ordered as follows. 1. The restriction imposed on the applicants are unlawful and their personal liberty be hereby restored. 2. The applicants comply with the COVID-19 SOPs. And 3. The respondents pay the cost of this application. A copy of the order was put on the court record by the applicant. Although I was convinced that the applicant had made out his case for amendment, I was convinced that the non-amendment of his petition would not necessarily be fatal to his case. A review of his petition showed that although he was constrained to prepare and file his petition in only 5 days, instead of the 15 days he was constitutionally entitled to, he had managed to plead the non-compliance with the principles set out in the law, and that Museveni the winner had committed electoral offences. As I pointed out earlier, either or both of the grounds, if proved, would be sufficient for this court, after concluding its inquiry into the petition, to make any of the orders it is permitted to make under Article 105 of the Constitution and Section 59(6)(b) of the Presidential Elections Act. The second reason related to the remaining proposed amendments. Having reviewed them from the copy that was attached to the application, I concluded that all those matters could be brought in within the petition as evidence. The third consideration that I took into account was the constitutional dictate in Article 104 of the Constitution for this court to conclude its inquiry and to make its decision not later than 45 days from the date of filing the petition. Although I was convinced that this obligation did not require the court to refuse a deserving amendment, any time saved by the court without prejudicing the parties would be in the interest of both parties, as it would give the court more flexibility to manage the hearing, inquire into the petition, and to render its decision. I will now proceed to read my reasons for allowing Kyagulanyi's application for extension of time to file his evidence in support of his petition. On 17 February 2021, Robert Kyagulanyi made a formal application for extension of time to file the remainder of his evidence. He filed miscellaneous application number 4, seeking for the following orders. 1. The time granted to the applicant for filing additional evidence in support of the petition be enlarged by 1 extra day to enable him file and serve all his compiled affidavits. 2, the respondents be given some extra days to file responses. 3, costs of this application be provided for. On 19th February 2021, this court, by a majority of 8, dismissed the application while allowed it for the following reasons. The application was supported by the affidavit sworn by Kyagulanyi, and was based on the following grounds laid out in the notice of motion. One, that the applicant filed the instant presidential election petition on 1st February and served it on the respondents. 2, that the filing of pleadings in this petition is still ongoing. 3, the filing of the additional affidavits in their petition is necessary to enable this honorable court effectively inquire into and determine all questions involved in the petition. 4, there are prevailing special circumstances that warrant the grant of this application. 5, the applicant has brought this application without any delay. 6, that the respondents shall not be prejudiced by extra time being granted to the petitioner to file and serve the additional evidence in the petition. And 7, that it's in the interests of justice, equity, and fairness that the applicant be granted extra time to file and serve the additional evidence in the petition. The application was supported by the affidavit of Kyagulanyi, where he listed the following additional grounds. And I'll just highlight that on 14th January, upon casting my vote in the general elections, I went back and interacted with our party officials on the progress of the elections, but around 1 p.m., I noticed that my telephone signals had been disabled. 3, that when I and my family woke up the following morning of 15th January, our home had been surrounded by the police and military personnel, effectively placing us under house arrest for the next 10 days. 6, that when I attempted to move out of my home to seek for legal advice from my lawyers and the decision of my party leadership organs on the next course of action, the police and military officers that had surrounded my house refused me from doing so. And there are many reasons which are reproduced here in his affidavit. I will not read all of it. Paragraph 30, that I will start with. I'll start with 29. That consequently, the decision from the Chief Justice through the Land Registrar was to the effect that, save for the evidence in 13 copies of Volume 2, out of which 7 copies had been received by 5 p.m. on 14th February 2021, the other copies of evidence would not be received, thus leaving the additional affidavits of evidence under Volumes 3, 4, 5, and 6. Copies of indices of the affidavits in Volumes 3, 4, 5, and 6 are herewith attached and marked as annexures E, F, G, and H. Paragraph 30 read that I immediately instructed my lawyers to file this application. But on 16th February, having been a public holiday, they told me that they would file the same on the following day of 17th February. Paragraph 32 read that the additional evidence I obtained from about 200 witnesses across the country is necessary to enable this honorable court effectively inquire into and determine all questions involved in the petition, in that A, it brings to the fore the various abductions, imprisonments, torture, and murder episodes of the petitioner's supporters by the agents of the first respondent and the third respondent. B, It reveals how results declared by the second respondent were falsified in favor of the first respondent. C. It brings to fore the various cases of robbery committed by the first respondent and by his agents. D. It brings to fore the circumstances under which the independence of the second respondent was compromised by the authority of the first respondent abusing the power of incumbency. E. It portrays the audio-visual expression of how the agents of the third respondent selectively enforced the electoral guidelines and used excessive force to frustrate the petitioner's election campaigns in favor of the first respondent. F. It brings to the fore the instances of voting in the names of deceased persons and persons out of the country. G. It brings to the fore how the second respondent relied on an incomplete, improper, and incoherent voters' register in the election. H. It brings to fore how the second respondent unlawfully, inefficiently, and covertly deployed a biometric voter verification kit, brackets BVVK, and electronic results transmission and dissemination technology system, in brackets ERDTS, without access by the petitioner and denying him the right to verify voters and audit the results. I. It brings to the fore how the petitioner's stronghold districts / cities of Kampala, Wakiso, Mukono, Mpigi, Gulu, Masaka, and note the first respondent stronghold districts of Kiruhura, Isingiro, Unyangabo, Kazo, Kamwenge, Kyankwazi were the epicenter of intimidation and violence against voters, and how this affected the percentage voter turnout in favor of the respondent as against the petition. 33 is a word that I state that there are prevailing special circumstances that warrant the grant of this application. And in 34, a word that leaving out the evidence sought to be adduced would assist the first respondent to commit electoral wrongs and get away with it, which has a significant impact on the peace, stability, and democracy of our country. And then he also pleaded that I have made this application without any delay in the circumstances of this matter. And lastly, that it is in the interest of justice, equity, and fairness that I be granted leave to file this evidence. The application was also supported by the affidavit of Wamedi Anthony, and I will not go over it, but I've reproduced it. Museveni opposed the application in the affidavit of Esau Isingoma, which he deposed on behalf of Yoweri Museveni. And I've reproduced what he averred. In paragraph 5, he said, with respect to filing of evidence, I know that this court gave the petitioner up to 5 p.m. on Sunday, the 14th of February 2021, to file all his evidence. 6. With respect to service, the court set up a desk at the Supreme Court and directed that each party should have a representative at the Supreme Court premises for purposes of receiving service of all the documents as soon as they are filed. 7. That as designated representatives of the first respondent, I attended court on the 12th and 30th of February in order to receive service of at least 50 affidavits, which the petitioner's advocates had indicated in court were ready for filing and service on 11th February. No affidavits were filed or served by the petitioner in the said 2 days. I attended court again on Sunday, the 14th of February, which was the final day of the petitioner to file all his evidence. At about 4 p.m., Mr. Richard Padoko, whom I know to be an advocate practicing with Rukwago and company advocates, came to without any affidavits, but informed me that the affidavits were on their way to court. At about 4:50, two other gentlemen came to court with 7 copies of one bound volume. The registry staff received and verified the documents presented in my presence. And so the affidavit also goes on, and in paragraph 13 says, it's not true that the affidavit of Kyagulanyi Sentamu, as alleged in paragraph 24 of the affidavit of Kyagulanyi Sentamu and paragraph 2 and 3 of the affidavit of Wamedi, that the petitioner's advocates were at court by 5 p.m. with 100 copies of affidavits bound together in 5 volumes. And then in the interest of time, I'll skip the other. In paragraph 18, continued that I've looked at the index pages of volumes 3, 4, 5, and 6 of the affidavit of Kyagulanyi, and I know that the petitioner seeks to introduce at a very late stage of the proceedings a very substantial number of new affidavits. I know that the first respondent will be seriously prejudiced in its defense, having just completed the exercise of identifying, transporting, and interviewing rebuttal witnesses from all over the country who have since been released to return to their various points of origin. I believe that the petitioner has not provided sufficient cause for time to be extended, and given the limited time available to complete this petition, it's not in the interest of justice for time to be extended for filing additional affidavits. In the circumstances, I believe that a grant of the application will compromise an effective inquiry in the matter in dispute in the present petition. I believe that it's in the interest of justice that this application be rejected. The second respondent, that's the Electoral Commission, also opposed the application, and the affidavit was sworn by Tashobia, a commissioner on behalf of the Electoral Commission. And he also deponed to many matters, which I will not read. In the interest of time. This Electoral Commission also relied, maybe before I go to the second one, I think it's important to read this. That the conduct of the applicant and his comments show that the instant application is brought in bad faith and an attempt to mobilize the public organs against this court, and is an abuse of the process of court. And then he also pleaded that I'm advised by my lawyers that the affidavits of the applicant are allegedly so detailed that the remaining time before trial is not reasonably adequate for the second respondent to comprehensively answer, and would be prejudicial to the second respondent and will amount to a miscarriage of justice. In paragraph 24, he pleaded that there are no special circumstances to warrant the grant of this application, and that he swears this affidavit in resolute opposition to the instant application. The Electoral Commission also filed a second affidavit by Bahige David Mutume, and I will not read it in the interest of time, but it's introduced. The Attorney General also opposed this application and relied on the affidavit of Alan Mukama, and he also deponed on matters which have been produced here. But in paragraph 16, just which I know that the third respondent shall suffer prejudice and inequity in the event that leave is granted to the applicant to file additional evidence in this matter. Submitting on behalf of the applicant, Counsel Segona submitted that this application for extension of time had been brought under sections 98 and 100 of the Civil Procedure Act, rules 15 and 17 of the Presidential Elections Rules, and Rule 2, 2, and 5 of the Judicature Supreme Court Rules. Counsel Segona considered that the applicant had failed to comply with the timelines which were given by the court. Segona submitted that the applicant seeking extension of time must show that special circumstances existed to warrant extension of time. He submitted that the restrictions that had been imposed on the applicant's movement for 10 days after the elections had impacted on his time and ability to collect his evidence. Further, relying on the grounds set out in the notice of motion and the affidavits of Kyagulanyi and his counsel Wameri, Counsel Segona contended that the other special circumstances this affidavit in this case were outlined in Kyagulanyi's affidavit and included the following. One, that the applicant had used some of the filing time he had been given to seek for bail for some key witnesses from the court-martial, and that these applications were surprisingly fixed for hearing on 15th February 2021. Two, that the office of the National Unity Party, hereinafter referred to as NUP, where some of his evidence was, had been under siege by the police and the military since elections until 15th February 2021. C, that the applicant only received security clearance from prison authorities to access his other witnesses who are currently in prison on 13th February 2021 and was only able to access these witnesses on 14th February 2021, the last day he had been ordered by the court to file his evidence. D, that some of the applicants would be witnesses had been abducted and thrown in distant places without any money for transport, which imposed an onerous obligation on the applicant to collect them so as to access their evidence. Counsel further submitted that despite the above challenges that the applicant and his counsel had faced to access his witnesses and to prepare his evidence and to submit it to court before 5 p.m. on 14th February 2021, the applicant had nevertheless managed to collect over 200 affidavits which were ready for submission once the court allowed the application. Relying on paragraph 32 of Kyagulanyi's affidavit, Counsel Segona further contended that the additional evidence of the petitioner/applicant will assist the court to effectively inquire into and determine all the questions arising from the petition. He further contended that this evidence is important, and so are the timelines for disposing of a presidential election petition. Furthermore, he argued that it was never envisaged that a petitioner applicant's liberty would be constrained by security forces. He further contended that there would be injustice caused if the court declined to allow the applicant's additional evidence, which has the capacity to overturn the outcome of the presidential election. Counsel for the applicant relied on several authorities listed in the bundle. Authorities filed in court contended that there was no inordinate delay in filing this application, as there was only 1 day delay. Further informed court that the applicant was ready to surrender 2 days of the time he had been allocated for him to make his rejoinders to the respondents to respond to the additional evidence. Further submitted that this case presents special and unique circumstances where you have a litigant in charge of the security of the others who used the power of incumbency to detain his opponent and their witness. His opponents and their witnesses. He contended that this alone presented unique circumstances warranting this court to exercise its discretion. He prayed to the court to grant the application and to adjust the time earlier given for filing of the respective parties' evidence. Responding to the court's question as to why this application had not been brought earlier than the deadline, before the deadline expired, or immediately on Monday 15th after the applicant had missed their deadline, Counsel Segona regretted that delay. He also informed the court that the applicant's counsel had not been working in their offices or sleeping in their home because during the period when they were preparing the applicant's evidence for fear of having a repeat of the 2016 events where the offices of the Petitioners' Council had been broken into and their evidence stolen. These fears were also based on the fact that the applicant's witnesses were being abducted. All the three respondents opposed this application. Submitting on behalf of the first respondent, 7, Council Tudayo contended that by the dictates of the Constitution, the petition had to be concluded in 45 days. He further argued that the court had given timelines and the respondents had only 1 day remaining to complete the filing of their evidence. Relying on the authorities he had jointly filed with the other respondents, Council submitted that the orders of the court are not mere technicalities and that they should be followed. Furthermore, he contended that if a party encountered any difficulties in observing the court orders, he was expected to immediately go back to the court and not wait as the applicant had done. Relying on the averments of his Ngoma, who saw an affidavit on behalf of the first respondent, Council Tudayo contended that in this case, the petitioner stroke applicant Kyagulanyi had failed to follow the court orders and that there would be consequences. He further argued that the petitioner stroke applicant had already had 33 days to file his petition and his evidence as compared to the respondents who were only given 3 days to file their respective answers. Relying on the Kenyan authority of Raila Odinga, where the Supreme Court of Kenya refused the petition to file an additional 7 affidavits, Council Tudayo contended that the first respondent would be greatly prejudiced if the court allowed the applicant to file an additional 200 affidavits drawn from witnesses spread out all over the country. Council further contended that a petitioner challenging the results of a presidential election must come to court with his evidence and not engage in a fishing expedition of looking for his potential witnesses when he's already in court. Relying on the decision of Venkata, Council Tudayo submitted that the applicant was expected to have his evidence when he filed his petition on 1st February 2021. Council challenged the relevancy of Kyagulanyi's averments in paragraphs regarding the restrictions on his movements soon after the elections, and the applicants claimed that the police and military officers who detained him at his home were under the direct command and control of the first respondent as the commander-in-chief of the armed forces. He further contended that these averments were speculative. Furthermore, Council contended that there was no justification for the applicant not to file his evidence by 5 p.m. on 14th February 2021 because he had informed the court earlier on 4th February in his application to amend his petition that he had discovered new evidence by then. Submitting on the other averments contained in the applicant's affidavit, Council Tudayo submitted that the applicant had failed to attach a list of his witnesses who are in prison, and that secondly, that some of the additional affidavits were for other witnesses who are not in prison. Council Tudayo contended that both affidavits of Kyagulanyi and Council Wamedi were full of falsehoods and could not be severed. He further contended that Rule 13 of the Judicature